Debate over Iowa's fetal heartbeat bill returned to a Polk County District courtroom today.
The bill has been on hold, of course, since Governor Kim Reynolds originally signed it back in 2018, and it's our top story now at 6. This afternoon, the judge heard from Alliance Defending Freedom, the legal advocacy group representing the governor, and the ACLU of Iowa. The injunction was granted in 2019 to block the law after the state of Iowa was sued. That lawsuit claimed the law is unconstitutional. It bans most abortions 6 weeks into a pregnancy.
But back in June, the Iowa Supreme Court reversed its decision from 2018, saying the court wrongly decided that abortion was a fundamental privacy right guaranteed in Iowa's Constitution. Later that month, the U.S. Supreme Court overturned Roe v. Wade. Reynolds' counsel says that injunction should be lifted.
As a result, my clients are here today asking this court to dissolve the injunction entered against them in 2019, because now that there is no fundamental right to an abortion in the state of Iowa's Constitution or the U.S. Constitution, now that it's clear that strict scrutiny is no longer the test, and now that it's clear that the viability line is no more, faithfully applying Iowa binding law requires the court to reach a different result.
Now, the fetal heartbeat law includes exceptions for rape, incest, and the health of the mother. During today's hearing, the ACLU of Iowa said that regardless of the state Supreme Court ruling, the request to lift the injunction is baseless.
This is a draconian and inhumane law that bans abortion at the earliest stages before many people know that they're pregnant. Judge Huppert's final order in 2019 permanently prohibiting the state from enforcing this law against Iowans closed this case, and the state's efforts to revive it and start enforcing the abortion ban are meritless.
That fetal heartbeat bill also protects women who get an abortion from criminal prosecution.